I submit this video with regard to the motion in limine assignment requirement for litigation experience on Thursday, April 2nd, 2015. May it please the court, my name is Casey Frank, and I represent the plaintiff Maggie Polizzi in this motion in limine proceeding. In particular, plaintiff Maggie Polizzi respectfully requests that this court limit evidence with regard to Jane Post's deposition in two regards. First, information regarding Maggie Polizzi's unwillingness to travel as a condition of her associate employment with Parker & Gould, and second, Jane Post's considerations of Maggie's entering class. In particular, plaintiff requests this information be suppressed first because it is not relevant and therefore is not admissible under general rules of evidence. In the alternative, because this information includes confusing the issues and needlessly presenting cumulative evidence into the trial. Beginning first with the relevancy of this evidence. Relevancy is ruled in this case by Rule 401 of the Arizona Rules of Evidence, which states that evidence is admissible if it is relevant, and evidence is relevant if, first, it has a tendency to make a fact more or less probable than it would be without the evidence, and second, if the fact is of consequence in determining the action. Now, in this case, we can see that neither of these requirements is met to allow relevancy into the two considerations. First, because both Maggie's unwillingness to travel when being considered as an associate position and the strength of her entering class are in no way probative and are in no way related or tied to her individual consideration for partnership, they are not relevant and should not be admitted here. Her unwillingness to travel is not relevant first, because it does not have a tendency to make a fact, in this case, more or less probable than it would be without the fact. First of all, Maggie's unwillingness to travel when she was considered for an associate position should not be considered in any way tied to considerations for her partnership considerations 7 years later. First of all, because the law firm was well aware of this requirement when they hired her for an associate. Second, because there is no indication in the record that this in any way detracted from her work product or the cases that she was assigned. And third, because there is such a large span of time between consideration for an associate position and a partnership position, and because of the distinct differences between considerations for associate and partnership, the latter of which requires a higher skill and ability level, that considerations regarding Maggie Polizzi's associate position should not be considered in their entirety because they have no tendency to make a fact regarding her partnership more or less likely. However, we limit this request specifically to the two components already addressed. In addition, with regard to Maggie's ability or willingness to travel, it is not of consequence in determining an action regarding gender discrimination, a hostile work environment, or quid pro quo, because all of those claims require that Maggie already be employed by the company, and all of her claims in regard to those issues only relate to issues after she became an associate at Parker & Gould, rather than her legal assistant position there. Additionally, with regard to defamation, this fact is not dispositive. It is not even relevant and should not be considered. The same is the case with Jane Post's consideration of the strength of Maggie Polizzi's entering class. Jane Post indicates in her deposition she believes that Maggie Polizzi's entering class may have been a weak one. But this is not probative of Maggie Polizzi as an individual, It only indicates Jane Post's personal opinions on why Maggie Polizzi may have been considered for an associate. We have already outlined why an associate is not the same as a partner, and why considerations for a potential associate should not be considered alike to considerations for a partner. However, additionally, Jane Post provides only an unsolicited opinion that is not supported in the record and does not appear to be tied again to Maggie Polizzi's considerations for partnership, particularly because the nature of considering an entering class is to consider the class as a whole, and considering a partner is considering that individual and their individual value to the company. That being the case, this is like comparing apples to potatoes. They are both food, but one grows in a tree, one grows in the ground. One of them is a fruit, one of them is a root vegetable. They are not alike in any realistic sense and should not be perceived as such. That being the case, it is clear that neither Maggie Polizzi's willingness to travel during considerations of her for an associate position and Jane Post's individual opinions and comments regarding the strength of Maggie Polizzi's entering class are not relevant and should not be considered here. Therefore, under a motion in limine, this information should be suppressed because it is inadmissible and should not be brought to trial. However, in the alternative, this court should suppress this evidence even if it finds that either of these components is relevant, because either component first provides a confusion of the issues, and second, because they needlessly present cumulative evidence. As stated, there is a disparity between an associate and a partner, and considerations for the two positions should not be considered alike. That being the case, it is confusing the issues to present negative information regarding Maggie Polizzi's consideration as an associate at Parker & Gould, because the associate position is so incomparable to that of a partner, and considerations of Maggie Polizzi's worth as a partner should be considered individually and separate from any other job consideration Maggie had at Parker & Gould. Second, this information also needlessly presents cumulative evidence, because the sole determination in this case is whether or not Maggie Polizzi was wrongfully treated by Parker & Gould through one of 4 claim mechanisms. And none of those claim mechanisms, sexual harassment, hostile work environment, quid pro quo, or defamation, contend any information that is negative treatment by Parker & Gould or Simon Clark in Maggie Polizzi's early years at Parker & Gould. It is only after Maggie Polizzi became an associate at the firm that she alleges negative treatment by the firm or by Mr. Clark. And in particular, it is only in her last years as an associate that she indicates any such treatment. That being the case, considerations of Maggie Polizzi or her third-party peers that are not party to this suit before she even became an associate are not relevant. But even if they are, they needlessly present cumulative evidence that should not be brought here. This cumulative evidence is simply a smear tactic by respondent, by defendant, to present Maggie Polizzi in a negative light. Parker & Gould did not have significant doubts about Maggie Polizzi when she became an associate, or they would not have hired her as one. Jane Post indicates the remarks and opinions of an individual, but does not present any dispositive evidence regarding the claims at hand today. Therefore, this evidence is needlessly cumulative and should not be brought before the court. In conclusion, plaintiff respectfully requests first that this court approve a motion in limine to suppress evidence regarding Maggie Polizzi's willingness to travel when she was considered for an associate position with Parker & Gould. and also suppress evidence regarding Jane Post's individual remarks and opinions regarding the strength of Maggie Polizzi's entering class, because neither of these factors is relevant to the claims at hand. In the alternative, plaintiff respectfully requests this court suppress that information on the basis that it violates Rule 403 of the Arizona Rules of Evidence, as both confusing the issues and needlessly presenting cumulative evidence. On the basis of this claims, plaintiff submits. Thank you.